So let's begin with Mr. Bavilski. We have a number of comments and responses and rebuttals to what's been said this evening and what's transpired in the last 2 weeks since the last meeting. When we left the last meeting, it was our understanding that there were two issues that were going to be addressed. Number one, the board was interested in knowing more about the question of structural alterations at the building, and that was followed up by a letter from Attorney McCann asking for to make arrangements for a site inspection, which was indeed held. The other issue that the board expressed interest in was to try to make contact with the Bureau of Prisons and to ask them a number of questions. That also occurred. What wasn't discussed at the last meeting was inviting Mr. Bavilski to get involved in this proceeding at all. So our first point is a question. Who asked him to review this situation?
Well, I think Mr. McCann, because we had asked him to understand reasonable accommodation that advise us on how best to apply the logic. And I think he then went to Adam, because he's a city employee, and asked if he could help.
We note that, the Firetree has, this proceeding's been open since May 4th. It dates back to matters dating back to last July and August, and we've never heard any suggestion by anyone in city staff that that was in any way relevant to this proceeding. So it comes as a bit of a surprise, and we really fail to see the relevance of this sort of desperate last-minute attempt. Mr. Bavilski hasn't reviewed the record. He said that. He admitted it again tonight that he hasn't reviewed the record. There's one statement in here I think that's very telling. Don't know why it's in here, but he notes that having a criminal record is not a disability under the terms of the ADA. Firetree's never claimed that. So why that would be in this letter is really a mystery. The department that Mr. Bavilski works in, it performs a variety of roles. We don't think that they're relevant to this. He does provide informal advice, as he stated, and reviews referrals from municipal departments. Really not relevant to this. Because the issue tonight is that the ZBA is faced with a special exception application. Mr. Bavilski's department has no role in the deciding of a special exception application or an appeal, for that matter, from a decision of the ZEO. In this case, Firetree was denied the certificate of occupancy, and this is for a facility that it had legally obtained zoning permit and building permit approval. Building permit sign-off, building department sign-off on the improvements and renovations that were made. The denial of access that is involved here is that Firetree has no access at all to this facility. They have been denied a certificate of occupancy. So the denial is total. This isn't a question of deciding whether a handicap ramp is needed or whether a particular accommodation is needed in terms of a specific building improvement. The issue here is that Firetree's been denied its occupancy in total. So the issue squarely lies with the ZBA. It really doesn't lie with his office. Only the ZBA has the authority to grant the special exception or to have granted the appeal, which was previously denied. I'd also note that the Human Relations Commission and the Fair Rent Commission that he provides advice to don't have a role in this proceeding. So we fail to see the relevance of bringing this up at the 11th hour, and it does seem it seems a bit desperate at this point. We have many responses to what's been said tonight and what's transpired. Let's start with the beginning issues.
Can I ask you a real quick question?
Yes.
You mentioned total denial, Firetree, and I'm presuming it's representatives that enter the premises. But that doesn't include the analysis of the structural change, the building inspector. I presume one of the folks from Firetree helped you.
Yes, I mean, obviously, people were allowed into the building, but for practical purposes, Mr. Chairman, they cannot use the property. Mr. Rinn went on record very early in this proceeding saying that Firetree absolutely could not occupy the premises. In fact, one of the emails, he chastised Firetree for even having anybody in the building. So there's no question that the denial has been total. I think at this point, though, before I get any further into my remarks and the response, we need to revisit one of the issues that has been raised in this proceeding. We've previously asked Mr. Levy and yourself, Mr. Chairman, to recuse yourselves from this proceeding. And we believe and continue to believe that the reason that recusal is appropriate is because both of you have demonstrated a bias against Firetree and have indicated very clearly that you have made up your mind about this application. The comments tonight confirm that. Mr. Levy's inquiries into a number of issues are clear indication that that bias has not abated in any way. The question about the building permit fee is a completely disingenuous question. It was asked at a prior meeting. It was asked again tonight. The simple answer is that Firetree did spend $639,000 on the renovations to the building. Not all of the renovations that it made required a building permit. You don't need a building permit to paint the inside of your house. You don't need a building permit to put new tiling in your bathroom or to put hardwood floors down. And what the architect told me is that he had a conversation with the building inspector and they talked about what the fee should be. And he put down the number on the building permit application plan of $350,000 that reflected the work that was to be permitted. And that was the number that the building department agreed to. So other monies that they've spent on things that don't require permits don't require an application fee. So this question about the fee is irrelevant, and it's indicative of someone who's really, I think, just trying to pick away at us. So,
May I respond to that, sir?
Not quite yet. I'm not done yet.
Okay.
Related to this, Mr. Chairman, is the fact that Ms. Campbell is once again sitting with us. Ms. Campbell is the regular member of the Zoning Board of Appeals. She's here tonight. She was here at July 13th meeting, and she was here at the May 4th public hearing when the proceeding started, when we made most of our initial presentation. It appears to us that you have unilaterally made this decision that Mr. Levy is going to sit in her place. And that is highly irregular, because Ms. Campbell is the regular member of the board.
It's not your judgment what's regular or irregular. Ms. Campbell, are you prepared to act on this tonight?
No.
Thank you.
So in any way, we are going to renew our request that both of you respectfully recuse yourselves from the proceeding. We have another alternate here. Ms. Alquin is here, as well as Ms. Campbell, who could have been asked to review the record. And so you do have 5 people that are available. There is a full complement of 5 available had you decided to do that.
And so you're suggesting that because they're here, we should go ahead and have Mr. Levy recuse himself, rather than substantially deciding whether or not Mr. Levy should recuse himself? because I've decided that it's not necessary that Mr. Levy accuse himself. But it's also up to him, and he has said.
And I think he should respond to that. I agree, Mr. Chairman.
I will not accuse myself. My inquiry as to the building permit fee was asked and not answered the first time I asked it. That's why I asked it again. And I don't think that shows any bias or predisposition as to my decision.
Okay. Neither of us are recusing ourselves, so on that issue is not something I want to go into further.
Okay, let's turn to the application. As we've discussed, there are 3 criteria that are associated with the request for a special exception. We believe that all 3 have been satisfied. Let's start with the easiest one, which is the 3rd criteria, which is the question about structural alterations. We presented the staff initially, and then the board has been copied on materials that were prepared by Sobolski Construction Company, which was the contractor for this work. First off, let me tell you that the spreadsheets that have been included in the materials that you have, those spreadsheets are based on invoices to a variety of different subcontractors which were hired. And those invoices provide the foundational basis for the numbers that are included in the spreadsheets that you have reviewed.
Now, let's bring this to a halt just real quick, because I made a ruling that we accept that we did not, or you did not exceed the 25%.
I want to be clear for your deliberations, because I don't know how your deliberations are going to go, and there may be board members that disagree with your view, so I want to be clear for everyone.
They might argue, but nevertheless, we've come to the conclusion that given the information we have, the 25% was not exceeded.
The fire escapes, let me just make this point, the fire escapes were replacements. And what the contractor did, okay, the contractor dismantled the old fire escapes and used them as a template from which to fabricate the replacement fire escapes so that they could be exact matches. So they are a replacement, they are both replacements of what was there. That is not a structural alteration. We did some legal...
Saying, under the category repair and replace.
It's repair and replace. It is clearly not a structural alteration to the building, and it shouldn't be included. So the number that Mr. Began mentioned before that was included in the materials, $36,600, is a conservative number, we think, for what was structural. It's probably less than that. I heard I think it was Mr. Levy suggest something about headers and windows being, there were no headers and windows moved. The builder was very clear on the tour. They did not move headers to doorways or windows. They simply did not do that. Let me point out one case, Lauren Monroe versus the Zoning Board of Appeals of the town of Branford. It's an appellate court case. The citation is 75 Connecticut Appellate 796 from 2003. It does provide an analysis of what is considered a structural alteration for the purposes of Connecticut zoning law. And it says this, quote, alterations that do not affect the size of a building and are limited to remodeling for appearance or efficiency are not usually considered structural alterations. So I'm going to provide a copy of this case for the record, Monroe versus Zoning Board of Appeals. All right, so the next 2 criteria that the board needs to review, of course, relate to appropriateness, and impact. And the first criteria, of course, is whether the proposed use is equally or more appropriate than the existing use, and whether the proposed use will have the same or lesser impact. We believe that the analysis for these two criteria really starts with the zoning permit plans that were approved in June of 2015. At the last meeting, we reviewed these plans in some detail. I should say I think it was the June 28th hearing, we reviewed these in some detail. Pivot operated a facility that was, in all aspects, a halfway house. It was a non-conforming use. Pivot used it to carry out its mission of helping alcoholics and drug addicts to recover from their addiction and substance abuse problems. Pivot's residents came to 17 Quintard after having spent time at their Bridgeport facility, and then they transitioned to another situation after, a true halfway house function. What Mr. Canary told you was that the most important things that they did for their residents was to help them manage their various appointments with the court system and corrections department officials. He called the facility an alternative to incarceration. You heard him tell you that over time they had increasing difficulty operating this facility in a manner that was safe and efficient. So he noted that their staffing was becoming too limited. They didn't have enough staffing. So as a result, they were shuttling their people back and forth from Bridgeport because that's where the programming was occurring that their residents were receiving. The health department was inspecting the building on a regular basis and noting many code violations year after year that had to be corrected. Pivot thought that Firetree was a good fit for this facility when Pivot made the decision that it had to sell that property and relocate their operations to Bridgeport. And so what happened was in June of 2015, this plan that we've talked about at length was submitted for a zoning permit application. And on the plan, it showed 18 beds. And it showed rooms labeled for a case manager, a director's office, a monitor room, a visitation room, a social services office. All those were labeled on the plan that the zoning officer approved. And so when this was approved, there was no question that it was a non-conforming use, and what was on this plan was considered a continuation of that non-conforming use. There's no dispute about that. It was a continuation of a non-conforming use. There was no other way that they would have approved this without reaching that conclusion. So in reliance on that decision, Firetree purchased the property. It then filed for a building permit application. And on that building permit application, the use group that was identified was I-1. It wasn't I-3, Mr. Levy, it was I-1 that was on that application. But in any event, it's an institutional classification. That's the key. It was openly applied for as an institutional classification, which in the code includes halfway house as one of the uses that would be appropriate for that classification. And the city approved that. And so Firetree then spent the money to complete those renovations. And so what you see now out there today is a fully approved building that the building department has signed off on. It's a lovely building. It has 6 bedrooms. It has room for 18 beds. The beds are made, by the way. The beds are in there. They're made. The pillows are nicely laid on them. The furniture is in there. Everything is ready to go. That's what is out there today. And that's really all done. Mr. Chairman, may I continue?
Keep it down. Remember, we can't hear when they're at the podium talking and you guys are also.
So what we believe you have to do when you're looking at impact and appropriateness is you have to start with the building that you see there today. Approved for 18 people, with staff, because the city was perfectly willing to approve that as an extension of a non-conforming use, a continuation of that non-conforming use. They were perfectly willing to approve it. So now we have to say, well, okay, where's the impact? All right, let's talk about that. Will Firetree have more beds than 18? No. Firetree's agreed to 17 beds and an average of 15. We've included that in one of the conditions of approval. Will Firetree have more visitors to the site than Pivot? No. It provided evidence that the number of visitors at their other facilities is minimal, and Pivot at the same time is admitting that they were shuttling people back and forth to Bridgeport regularly because they didn't have the staff to run it properly. Will Firetree create more demand for on-street parking? That's been a question, and the answer is clearly no. Because Firetree's agreed to take down the garage that's in the back and to provide additional off-street parking spaces. So Firetree will have more parking than Pivot ever had. More parking than Pivot ever had. On-site, off-street parking. So clearly there will not be a greater on-street parking demand from Firetree. Looking at other aspects to this, will Firetree have better management of its residents? Of course they will, because they run a better operation than Pivot did. Mr. Kinnery was sad to admit that, but it's true. They couldn't run it right. Firetree has a track record of running very good facilities, and they will have more people there than Pivot did. Will Firetree have greater knowledge of resident sobriety? Absolutely yes. Firetree does regular screening for drug and alcohol use, which is far more than Pivot did. How about property values? We know from the most recent assessment records that the appraised value of the property has increased $275,000 before and after Firetree's acquisition and renovation. $275,000 increase in the appraised value of the property in the time period that they improved it and renovated the building. So what is left? After going through all of those objective measures of impact, what is left? The only thing that is left is that there's been pointed to as a history of incarceration, as a distinction. But Mr. Kinnery told you that most of the people they had were in and out of court, in and out of parole officer meetings. They all had a close contact with corrections and the judicial system. So that's not a difference. So if you honestly look at this, we think when you take into account what was approved and what Pivot left as the nonconformity that it had, Firetree will have no greater impact and probably less impact than Pivot did. And the same thing goes for its appropriateness in the neighborhood. In addition, we've offered to you conditions of approval that we think should assist you in trying to help find ways to incorporate into the special exception approval appropriate conditions relating to the operations of the property. I'd like to just run through a couple of just miscellaneous questions or rebuttal points relating to questions and comments that have come out this evening. With respect to the reasonable accommodation request, we believe that the legal framework we've given to you before is the correct framework to view this application through. And that framework is set forth in many, many cases interpreting the Fair Housing Act. And that test has 4 parts to it. And the first part asks the question whether a majority of the future inhabitants are indeed disabled. Now, under the Fair Housing Act, this is really important. Under the Fair Housing Act, the test for whether they have a disability or not is whether they have a physical or mental impairment which substantially limits one or more life activities, or there is a record of having such impairment, or they are regarded as having such impairment. Now, in this case, Firetree has given you very good evidence of the populations that it serves at its other 2 reentry facilities, Harrisburg and Syracuse. And in those 2 facilities, there were 70 and 75% of those populations that demonstrate mental or physical impairment or are recovering from drug and alcohol abuse. I've heard it said tonight and in other commentary that we haven't provided you with enough specificity about the disabilities. We disagree. We've given you the data from those 2 other facilities. We've also demonstrated to you and given you some literature that shows you that the prison population in general exhibits percentages that are close to that. So it shouldn't be a surprise that they indeed have 70 to 75% disabled individuals. And I think it's also important to distinguish the commentary tonight that Mr. McCann reported on from his conversations with the Bureau of Prisons. What Amy Ertl, Vice President of Firetree, has told you is that Firetree also does its own independent screening of each resident when they first arrive. So they're making an independent assessment as well. They take that condensed medical history that Mr. McCann referenced, they take that as a starting point, but they also do their own assessment to determine whether one of the disabilities is present. And that helps inform them how to tailor the services that need to be provided to each resident, because each resident has an individualized plan associated with them. So we think we clearly satisfy that prong. The second part of the analysis is the proposed accommodation necessary for the particular disability? And for starters, obviously, the accommodation that we've asked you for is needed. We need the special exception permit because the appeal has been denied, the tenant occupancy permit was denied, the certificate of occupancy was denied. But more importantly, this building is now uniquely outfitted for Firetree's use. It has in it features which are necessary for the use group as a halfway house. So it has a fire sprinkler system. It has handicap ramps. It has the dedicated water line for the sprinkler system. It has these specific features, making that property unique. It has a room configuration which suits that use. The empirical studies that we've presented to you and that Amy has described for you demonstrate that the congregate setting is helpful in combating relapse for drug and alcohol addicted individuals, and it also aids in the recovery of mental and physically impaired people. We've demonstrated that this is necessary because the financial feasibility of the project requires the 17 beds with a 15-bed average. We've demonstrated that Firetree has a service delivery model which is designed to assist these people and the disabled individuals to get the help that they need. So, for example, Firetree makes referrals to the appropriate medical professionals. They monitor for medications. They facilitate attendance at AA and NA meetings, and they conduct regular drug and alcohol screening to ensure that their residents remain sober. They provide employment counseling, life skills coaching. All of this would not occur without them able to provide their services at this facility. So the reasonable accommodation that is requested, which is to allow this change from one non-conforming use to another, is needed for them to be able to provide their services directed to individuals with disabilities. And it can't be done in just any building. It's an erroneous idea that this is a fungible property that could be transferred to some other location. A building like this is uniquely suited, and this building is particularly well suited, particularly given all of the renovations that have been made to it. The third prong of the analysis for reasonable accommodation and the fourth prong are the following. Does the request impose an undue burden or expense on local government? The answer is no. There's no additional cost to the city. And I think we noted that Mr. Bavilski's opinion was that any issues with property tax diminution is insignificant and de minimis in the context of a $300 million budget. Finally, does the proposed use create a fundamental alteration to the zoning scheme? We say absolutely not, for all the reasons that we've described, particularly relating to the status of this building as a non-conforming use. There's been no evidence submitted that there is a direct threat to public safety associated with the application. Firetree's experience supports this, and they told you about that. We've said all along that Firetree should never have had to have arrived at this point tonight, that the CO should have been issued, the tenant occupancy permit should have been issued. And what really happened was actually about a year ago this week. A year ago this week was when neighborhood opposition arose and pressured the mayor to pressure staff to not issue the CO. And I think the mayor's email to Mr. Rinn said it all. He said, we've got to quell the uproar. That's what this was all about. Let's quell the uproar. And from that point on, everything changed. Everything changed. Everything was fine up to that point. Everything changed at that point, and it has just been no, 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 no ever since then. I'd like to have Ms. Ertl just speak to a couple of the issues to wrap up our presentation and rebuttal. I'd like to just first of all ask you to review the independent screening that you do at your facilities. when residents first come to your facilities?
We do a medical screening, we do a life skills assessment, we do a employment assessment, and we sit down and do an in-depth review with each client of their medical history and their work history and everything else to figure out what they need. It's all part of and depending what else we need, whether we need to do a depression index review or any other suicide or any other assessments based off what we do to build up the prescriptive program plan.
And can you also describe the demographics again of your federal population at Syracuse and Harrisburg?
In terms of disability?
Yes, in terms of the disability.
We accept from 18 and over, and currently over the last 5 years, our demographics are running that we're approximately 70% disabilities, ranging from medical or physical handicaps to mental health issues to substance abuse issues.
There's been a comment made that there may have been additional offices added to the plan. I want to just be very clear that the zoning permit plan that was approved in June of 2015 showed a director's office, a case manager's office, a visitation office, a social skills office. So those were on the plan that was approved, and there's no new office space that's been added in this building since that time. So in conclusion, we ask the board to approve this special exception. We think we have satisfied your criteria. We've given you conditions of approval that we hope you'll consider. And we thank you for all of your patience and hard work on working on this. Are there any questions?